The right of redemption allows a mortgagor to redeem property that's been foreclosed on by paying the mortgagee the difference between what is owed and the property's sale price. But what if a mortgagee with two mortgages acquires the property at a foreclosure sale and destroys the mortgagor's right of redemption? May the mortgagee still hold the mortgagor liable for the debt on the other mortgage? The Arizona Supreme Court considered this question in Mid-Kansas Federal Savings and Loan Association of Wichita versus Dynamic Development Corporation. In May of 1985, Dynamic Development Corporation, a real estate developer, obtained financing from Mid-Kansas Federal Savings and Loan Association of Wichita to construct 10 speculative homes in a subdivision. The money was dispersed in 10 loans, and each loan was evidenced by a note and secured by a deed of trust, similar to a mortgage. In January of 1986, Dynamic took out an additional $150,000 loan from Mid-Kansas to complete construction. The second loan was evidenced by a note and secured by a deed of trust on the 7 lots that hadn't been sold. In the summer of that year, both notes became due. After Dynamic failed to pay off the debt on the remaining lots, Mid-Kansas initiated a foreclosure sale on the second note and mortgage. At the time of the sale, Dynamic owed $425,000 on the first note and $102,000 on the second note. Mid-Kansas bid on the 4 available lots at the sale with the credit it was owed on the second note and acquired title to the lots. Subsequently, Mid-Kansas sued Dynamic in state superior court, seeking waiver of the security of the first deed of trust and for the balance of the debt due on the first note. In the action, Mid-Kansas moved for partial summary judgment on its debt claims, which the court granted. Dynamic appealed to the Court of Appeals, which reversed and remanded the case for entry of judgment for Dynamic. Mid-Kansas then appealed to the Arizona Supreme Court.